Hi, this video will introduce you to substituted service via social media. I'll firstly explain what substituted service in initiating proceedings means before discussing two cases where courts have permitted defendants to be served using social media. Firstly, let's have a look at some definitions. Service is defined as the act of delivering or exhibiting a writ, summons, complaint, notice, or order by an authorised person to a person party to an official proceeding. Ordinarily, personal service is required to initiate an action, which is generally effected by leaving a copy of the originating process with the defendant. However, where a plaintiff experiences difficulties in effecting personal service, they can seek an order for substituted service, which dispenses with the need for the document to be served personally. There are two requirements for substituted service, namely, that the personal service must be too difficult or impractical, and that the substituted method proposed must be likely to bring the proceedings to the defendant's attention. It is easy to see how the internet could assist in effecting service on people who are outside of the country or otherwise unable to be served personally. In particular, there have been some recent cases which have attempted to use social media to effect service on parties to proceedings. This was seen in the landmark case of MKM Capital Proprietary Limited and Corbo and Poyser, where a lender attempted to serve a default judgment on two mortgagees following their default on their mortgage repayments. This was attempted to be served via their Facebook accounts. The service was deemed effective as the mortgagees' names, birth dates, and email addresses corresponded with the Facebook accounts, satisfying the ACT Supreme Court that the Facebook accounts did in fact belong to and were monitored by the mortgagees. However, substituted service via social media has been treated somewhat cautiously by other Australian courts, as it raises potential issues with respect to the identity of the person served. In Flowrider and Mothership Music Proprietary Limited, the musician Flowrider was paid $55,000 in advance payments for his appearance at a concert in Newcastle, in New South Wales. Flowrider failed to appear at the concert, and the concert organisers, Mothership Music, attempted to serve an originating process to Flowrider via his Facebook page, which was linked to the official Flowrider website. As he did not respond to the process, a default judgment was awarded to Mothership Music in the first instance. Flowrider then successfully appealed this decision on the basis that the originating application was not properly served. This was because the evidence provided did not satisfy the presiding judge that the Facebook page was linked to and operated by Flowrider, so that he would be sure to receive the notice of service. In summary, substituted service via social media is potentially an efficient new way forward in utilising the internet to serve parties who might otherwise be unreachable. However, those wishing to use this method of service should keep these few pointers in mind. Firstly, plaintiffs should be careful to ensure the social media account being served actually belongs to the defendant party. This could be done by providing the judge with sufficient background information on the operation of the social media account. Also, it would be prudent to ensure that the social media site allows for the website to be a forum of service in their terms and conditions. In addition, you also need to consider whether you are breaching any privacy laws in effecting service in the public forum. And finally, you should be mindful that rules for service are different across different legal systems globally, which could affect your otherwise effective attempt at service via social media.